Hello and welcome to the lecture for business law. And today we're going to be emphasizing in contract law. At the end of this lecture, the objectives that we'll want to be able to complete are to be able to list and explain the hurdles to jump in forming a legally enforceable contract, describe the purpose of third parties in contracts, describe how changes in contract assignments, delegations, and novations affect third parties, explain the procedures of contractual discharges and remedies in the event of a breach of contract. We will begin our lecture by talking about the contractual hurdles that need to be jumped in order to form a legally enforceable contract. The contractual hurdles are listed in chronological order as follows: classification, interpretation, offer, acceptance, consideration, capacity, legality, and genuineness of assent. Before we move on, there are a few things to take note of. First, the content of contract law is extremely extensive. Therefore, I will do my best to keep this discussion somewhat detailed while keeping it simple and educational. Since business law has a very extensive scope as well as a very high level of relevance to the main lecture of the buying and selling life cycle, this lecture will be the longest of the 4 lectures. Also, you will find that there are a lot of general rules to contractual conditions as well as exceptions to these general rules. In a few cases, there are even exceptions to the exceptions, which can be pretty confusing, but feel free to rewind the video at any time to repeat any difficult or confusing concepts in an effort to understand it better. Lastly, there are a few important suffixes to remember when talking about contractual parties. Or, as in assigner, refers to the party in initiating the action, whereas E, as in assignee, refers to the party who is the recipient of that initiation. In the case of lawsuits, the plaintiff is the party that files a lawsuit, whereas the defendant is the party who is defending themselves against the plaintiff. The first hurdle to jump in forming a contract is deciding what type of contract we want to construct. There are 5 categories in contract classification. First, we need to decide whether the contract will be bilateral or unilateral. A bilateral contract is an exchange between 2 parties of one promise for another to perform the contractual obligations in the future. A unilateral contract is an exchange of a promise for an actual act. In other words, I cannot simply promise prior to an action in a unilateral contract. I must actually perform the act prior to the contract becoming legally enforceable. The second category includes deciding between an express, implied in fact, or implied in law contract. Although some states differ on express contracts, it is generally a contract where parties agree and indicate who the parties are, what the subject matter is, the price, and the time set for the performance. Implied in fact contracts need 3 elements to be enforceable. First, the plaintiff furnishes something valuable to the defendant. Second, the plaintiff expected to be paid for the performed services while the defendant was aware of this. Third, the defendant had a chance to reject the benefit. Implied in law or quasi-contracts are not actual contracts, but an equitable substance for a real contract. The purpose of quasi-contracts are attempts to avoid unjust enrichment. This option is not available when the terms are defined by a real contract. The third category includes formal and informal contracts, which are different in which formal contracts use negotiable instruments, whereas informal contracts do not. The fourth category of contract classification includes valid, void, or voidable contracts. Valid contracts are contracts where all the elements exist and thus is an enforceable contract. A void contract is a contract that cannot be enforced despite the clear intents of the parties. A voidable contract is a contract that is voidable at the option of one of the parties and sometimes both of the parties. The final category of contract classification includes executory and executed contracts. Executory contracts have at least one contractual obligation left undone. Executed contracts are contracts that have been fully performed. After we classify our contract, we must know how to interpret the contents. There are a few rules to follow with interpretation. First, we must consider the plain meaning rule, which basically implies that written content in the contract will always be more compelling than oral statements in court. Therefore, you should always make sure that the terms that you want are always in the written contract, because oral statements are not legally enforceable. Sometimes contracts won't have a clear meaning and may be ambiguous. In these cases, ambiguities are interpreted against the party that it was responsible for including it in the contract. When forming a contract, it is important to be objective with your intentions, because according to the objective theory of contracts, intents are judged by the outward objective facts, particularly the words, conduct, and circumstances. Now that we know how to classify and interpret a contract, we are ready to discuss the first action hurdle of contract formation, which is the offer. In order to give another party the power of acceptance, 3 conditions must be met. First, there must be an intent to be bound. Second, the terms must be definite and certain. Last, the offer must be communicated to the offeree. Please note that the offerer is the one offering the contract and the offeree is the one accepting the contract. The following scenarios are not considered live offers: expressions of opinions, statements of intentions, preliminary negotiations, ads or catalogs, agreements to agree in the future, and auctions. There are 2 ways in which an offer can be killed: the acts of parties or by operation of law. An offerer is free to revoke the offer at any time prior to acceptance. A few exceptions to this rule are option contracts, unilateral contracts, firm offers under the Uniform Commercial Code Article 2, or more simply the UCC, and promissory estoppel. Promissory estoppel is simply defined as an enforceable promise regardless of formal consideration. Upon receival of an offer, the offeree can simply take it or leave it. However, there needs to be a clear communication of acceptance or rejection. There are a few clarifications that we need to understand in order to more fully understand the rules of an offer. Sometimes the offeree will test the firmness of the offer just to fish for the best deal. This is not an acceptance of the offer. Additionally, counteroffers are not considered an offer. In fact, a counteroffer actually kills the original offer. Also, there must be a clear no to reject an offer. The other method where an offer can be terminated is by operation of law by any one of these elements: lapse of time, destruction of subject matter, sudden death or mental incompetency of either party, or a change in legality of an offer. Once the offer hurdle has been jumped, the acceptance hurdle is up next. There are 3 requirements for a legitimate acceptance. First, there must be voluntary words or conduct by the offeree. Furthermore, the offer must be inherently personal to the offeree. Exceptions to this include public offers or option contracts. Silent or inaction is not considered a qualified acceptance. A few exceptions to this are implied in fact contracts or silence being included in the contractual terms as an acceptable form of acceptance. The second requirement is that there must be an unequivocal expression of agreement. The acceptance must mirror the terms of the offer. This is called the mirror image rule. The third requirement is that there must be clear communication to the offerer. Under the dispatch rule, the acceptance is finalized when the contract is dispatched rather than when it arrives. For example, if you're mailing your acceptance, it would be finalized when it is sent, rather than when it is actually delivered. A few exceptions to this rule include nullification by the offerer, improper addressing, and when the offeree sends a rejection first. After there has been an offer and an acceptance, we have to jump to the consideration hurdle. The general rule is that there must be valuable consideration on both sides in order to make a contract enforceable. There are two core elements that must be considered. First is the bargain element. This considers the motivational focus of each party. Second is the value element, which considers the conditional legal position changes. There are a number of exceptions to the general rule, which can substitute for consideration, including charitable acts, promissory estoppel, formal contracts, a revival of debt that is discharged under statute of limitations, a minor's affirmation of a contract, and a promise to pay one who could otherwise get quasi-contract relief. After the consideration hurdle is done, the hurdle of contractual capacity is next in line. The purpose of this is to make certain that each party is fully aware that they are each entering a legally binding contract. Adults are generally considered to have contractual capacity, except when that adult is mentally incapable of understanding such a capacity. However, minors actually have contractual incapacity for a number of reasons. They are presumed incompetent. However, they must either accept all of the contract or none of it when choosing to avoid or take a contract. Minors have an avoidance power for a reasonable amount of time. When it comes to living necessities, minors can avoid the contract, but they must pay a reasonable value. Minors also have no duty of restitution and can avoid a contract regardless of the misrepresentation of age. After we pass the capacity hurdle, the next part is the legality hurdle. This refers to the law setting boundaries for contracts. There are three areas of contractual legality, including statute violation, tortuous or criminal conduct, and incompliance with public policy. These three areas are what set the contractual boundaries for legal compliance. Under statute violation, there are a few things to consider regarding contractual legality. Usury means charging excessive interest rates past the legal bar. Obviously, we probably know the definition of gambling, but private bets specifically are unenforceable. If a particular license is required to enter into a specific contract, then that license must be held in order for the contract to be enforceable. For obvious reasons, tortuous or criminal conduct is surely not going to be enforced by the law. There are a few scenarios to consider with contracts against public policy. Exculpatory clauses seek to relieve one of the parties from the consequences of their own faults. These are unenforceable. When there is a prohibition of marriage, then there is no legal enforceability. In regard to restraints of trade, it is against public policy and will generally be unenforceable as well. There are a few exceptions to this, however. It includes covenants that are not to compete in employment or business sale context. It must also be reasonable with the scope of time and geography. If it is too broad, the court will reasonably narrow down the terms or they will completely ignore them. As a general rule, who is in equal fart or in pari delicto gets any relief. If one party is enriched in this scenario, then tough. This is because instruments of justice would lose its credibility if it provided aid to a faulty party. However, there are a few exceptions to this rule. If the ignorance was justified, then that party was not in pari delicto. If one party sought to be protected by a law that was broken, then that party is also not in pari delicto. One party who is guiltier because of fraud, duress, or undue influence, then that party has the greater fault. Additionally, in cases of partial illegality, the illegal portions can be voided and the legal portions enforced. The final hurdle in the contract formation is the idea of genuineness of assent. This is referring to each party's level of genuine agreement to the contract and its terms. The unit of measurement in this party's intention with forming the unit of measurement in this each party's intention with forming the contract. Generic mistakes are not grounds for legal action because the mistake must be significant and undeniable to be legally actionable. This does not include cases where one party knows more information than the other. There are 5 categories of this hurdle, including mistake, fraud, innocent misrepresentation, undue influence, and duress. This diagram is a helpful guide to analyze the legal consequences of a mistake. Remember in the last slide that in order for a mistake to be legally pursued, it must be factual and material. If a bilateral contract was involved, then there will probably be some sort of relief to the victimized party. For unilateral contracts, there will be no relief with a few exceptions. First, the offending party knew or should have known of the mistake. Second, the mistake was caught and communicated before the offending party changed their position in reliance. This is precisely how many mistakes are actually legally punishable and how many are just simple generic mistakes that happen often. Fraud is a very important principle of genuineness of assent. There are a few prerequisites to conclude that an action was fraudulent. First, there must have been a certain misrepresentation of facts. Silence or omission doesn't fall under this category unless there was a serious or dangerous hidden defect, a breach of fiduciary duty, or a broken statute caused by the silence. Active concealment, intentional misstatements, and false denials count as fraud. It is not, however, a mere opinion or value. Scienter is another attribute of fraud and is defined as knowing a falsity or recklessly disregarding the truth. Fraud is also defined by a justifiable reliance upon a misstatement. Lastly, to keep the subject matter of the contract and is suing for the damages instead of contractual repeal. Lastly, fraud includes a causal connection to injury. This is applicable only if the victim wants to keep the subject matter of the contract and is suing for damages instead of contractual repeal. Innocent misrepresentation is essentially the same as fraud, except without the quality of the scienter. Usually courts only allow rescission in this circumstance. Undue influence refers to assenting to a contract being under the influence of another person. There are 3 elements to this allegation. First, there is a fiduciary or confidential relationship involved. Second, the plaintiff exercised no individual judgment and relied on the defendant's judgment instead. Third, the defendant took advantage of the plaintiff. The last principle of genuineness of assent is duress. There are 2 types, physical and economic. Physical duress refers to the physical force or threats of force against the plaintiff and his or her friends and family. Blackmail, which is a form of physical duress, can either involve threatening criminal prosecution or threatening to reveal embarrassing facts. Economic duress occurs when the plaintiff was operating under some compelling economic need and either the defendant caused that need or the defendant actively made that need worse. This does not, however, include driving a hard bargain. There are 2 concepts to consider when analyzing whether a contract is required to be in written format in order to be legally enforceable. The legal rule of the first principle, the statute of frauds, is that so long as a contract can be proven, it is legally enforceable. However, there are a few exceptions to this rule. The sale and interest in land. The following are few sub-exceptions to this exception. Partial performance, possession transferred, or improvements made. The second exception is that the terms cannot be performed within 1 year. Third, secondary promises to pay one's debt doesn't count unless the primary purpose counts. Fourth, promises that were considered in a marriage doesn't warrant a legally enforceable contract. Fifth, a sale of goods that ranges above $500 or lease of good that ranges above $1,000. The second concept, the parole evidence rule, deals only with written contracts. It is the idea that the admission of evidence can be added or taken from a written contract, cannot be added or taken from a written contract, lest the terms are contradicted. In other words, this is an exclusionary rule of evidence. This only applies to the disputes over the content of a contractual term and things happening prior to or coexistent with the contract signing. Make no mistake, fraud, duress, lack of consideration, and other legal defenses can still be proved. At the end of a contract, there are usually merger or integration clauses that activate this rule. Now that we know the process of jumping the contractual hurdles, we will now discuss how third parties are involved in contracts concerning their rights and obligations. A third party is any party involved in the contract other than the originating two parties. Generally, third parties have no rights or obligations in contracts due to the two original parties being in what we call privacy of the contract. There are 4 exceptions to this rule, including assignments, delegations, novations, and third-party beneficiaries. An assignment refers to the assigning of a party's rights. There are 2 kinds of assignments, gratuitous and non-gratuitous. Gratuitous assignment is a gift without any consideration in return for the right to the gift. These are freely revocable and carries no implied warranties. On the other hand, non-gratuitous assignments are irrevocable and carries implied warranties. In the next few slides, you will see a diagram model that we will use for our discussion of third parties. Please note that A refers to the obligor, B refers to the obligee or assigner, and C refers to the assignee. Assume that C is the third party and the original contract was made between A and B. In this case, A is obligating B to perform a service or to give an item in exchange for the appropriate reward. In a gratuitous assignment, B is assigning the right to the reward to C unconditionally without any consideration for that reward. That is why this assignment can be thought of commonly as a gift. In a non-gratuitous assignment, the key difference is the right to consideration for that gift that B gave to C. This means that B gives the gift to C only conditionally upon the appropriate return. So as long as this condition is met, B surrenders the right to receive the payment over to C. So A would pay C instead of paying B. In a non-gratuitous assignment, Party B impliedly warrants 5 factors: a valid claim to the assignment, a good title to it, that the rights are genuine, that Party B won't impair any collection efforts to Party C's assigned rights, and has no knowledge of any defenses that Party A would effectively raise to avoid performing contractual obligations to Party C. Generally, all rights can be assigned with a few exceptions, including statutory prohibitions, contractual prohibitions, inherently personal contracts, and a material increase of Party A's burden of performance. Although it is not required for Party C to notify Party A of an assignment of rights, it is unwise to fail to do so. There are a number of reasons for this. First, the timing determines the priority among multiple assignees. Second, Party C can obtain contractual discharge. Third, it cuts off Party A's ability to use collateral offsets. To avoid this issue, Party A should always verify the correct assignee via written and signed document. If you are Party A, you should bring interpleader action against both parties in the event that Party B denies assigning rights to Party C after Party C notifies you of the assignment. The second way that third parties can obtain contractual rights is through the delegation of duties. Although Party B can assign the burden of duty to Party C, Party B still maintains residual liability regarding delegation in the event of a breach of contract. Like the assignment of rights, all duties can generally be delegated. The exceptions to this include inherently personal contracts, material variance in what Party B will receive, and contractual prohibitions of delegation. Here you can see that not only is the right being assigned to Party C, but also the burden of performance. Remember that although Party C is doing the work, Party B still carries the residual liability. Therefore, if you are Party B and thinking about delegating to Party C, you better make sure it is someone you trust that will keep the terms of the contract. Novations are almost identical to delegations, except for one major difference, which is the transfer of residual liability. Party B delegates the duties and the liability to Party C in a novation, thus turning the delegation into a novation. It is as if Party B is obtaining contractual discharge by giving it all to Party C. However, Party A must grant a novation when it is requested by Party B. This tells us that although novation is a possibility for Party B, it is ultimately up to Party A whether or not that novation will be permitted. This basically represents what we discussed. As you can see, it is as if a new contract is being formed and parties A and C, with parties A and C, while Party B is obtaining contractual discharge. Third-party beneficiaries are most relevant to life insurance cases, so we won't discuss this principle much since it doesn't really relate to our latter discussion of the buying and selling life cycle. However, feel free to pause and study this flowchart to become more familiar with the concept of third-party beneficiaries. Knowing the contractual hurdles as well as the role of third parties, the next section of our discussion includes how parties can either be dismissed from their contracts or receive the relevant relief, or even both in the event of a breach of contract. First, let's touch on contractual discharge. It is simply defined as becoming free from the obligations of a contract. The most common way to obtain contractual discharge is to fulfill all the contractual obligations. There are a few conditions of contractual discharge that should be noted. First, these conditions can be used to shift the risk of something happening or not onto the other party's shoulders. Second, conditions can be used to powerfully induce the party to fulfill a certain obligation, such as a time is of the essence clause. Third, conditions need to be contrasted from covenants. Covenants recover damages in the breach, but doesn't grant contractual discharge. Conditions recover damages and allows contractual discharge. However, both of these are legal conclusions that are ultimately made by the judge. Fourth, the failure of conditions is not considered a breach unless the other party is responsible for its satisfaction. Fifth, if the consequences of a breach are too harsh relative to the offense, it may be treated under the rules of a covenant. There are also a few legitimate excuses that justifies a condition not being applied, including a waiver, hindrance from one party that prevents and sabotages the contractual obligations being met, and substantial performance of the contractual terms. Regarding the performance of the contractual expectations, there are three different levels with different levels of consequences. First, there is full performance from one party, which disables the other party from getting neither damage relief nor discharge. Second, there is substantial performance, meaning that the performing party made a reasonable effort to fulfill the contractual obligations, but still didn't meet all the obligations. This amounts to damage relief, but not contractual discharge for the other party. Lastly, there was a material breach level, which means that the performing party fell far below the contractual expectations. This gives the other party the right to damage relief and discharge. There are a number of methods by which contractual discharge can occur. These methods are grouped into two core categories: by mutual agreement between the parties and by operation of law. Let's begin with the mutual agreement. The first method is through mutual rescission, where parties agree to go back to square one before the contract is formed without replacing the original contract with the new one. Another way is through a novation, which was discussed earlier. Parties can also achieve accord and satisfaction, which replaces the old contract with a new one. The next key method used for discharge is through operation of law. If one party materially alters the contract, this will grant discharge. If the statute of limitation has expired, meaning the reasonable amount of time to take legal action is passed, The plaintiff waives their own rights to obtain discharge. Another interesting way to obtain discharge is through bankruptcy. Think about it. By filing for bankruptcy, you are either allowing your creditors to liquidate your assets under Chapter 7 or denying your creditors' rights to collect from you for another 3 to 5 years under Chapter 13. Either way, you'd be getting out of your financial contractual obligations in either case. An anticipatory breach, which is another form of by operation of law, occurs by a party expressing an undeniable intent to not perform material contractual provisions. Impossibility is another method. There are two types of impossibility: objective and subjective. Objective is the idea that no one else can fulfill the contractual promise. This is evident in cases of the destruction of specifically identified subject matter or changes in the law. Under subjective impossibility, another person could reasonably fulfill the contractual obligation. Common cases of this include residual debt after death and self-created impossibility. In the first case, this is very common when someone dies and their spouse or child or other family member is given the debt responsibility. Commercial impracticality is another method by which the operation of law can grant contractual discharge. This refers to the idea that there is a problem that was neither foreseen nor reasonably foreseeable at the contract formation and consequently causes a burden of performance that materially increases. The last method through the operation of law is by frustration of purpose. This is when there was an unexpected event that occurs that would have affected the decision of a party to enter the contract in the first place. Of course, this would generally prompt contractual discharge. Now we will discuss remedies. When a party fails to meet contractual obligations and there is no way to grant contractual discharge, remedies are applied. Remember that remedies are also applied in cases of material breach, and in that case, there is both contractual discharge and damage relief. There are two types of remedies: remedies at law, which focuses on money, and equitable remedies, which focuses on anything other than money. First, we will focus on remedies at law. The purpose of these types of remedies, is to give the non-breaching party the benefit of their bargain at a reasonable amount. There are 5 types of remedies at law, including compensatory damages, consequential or special damages, punitive damages, nominal damages, and liquidated damages. Compensatory damages are designed to compensate for plaintiff injuries that were caused directly and naturally by the other party. This is not for plaintiff-specific cases, meaning that anyone would be expected to experience the same loss as the plaintiff. Compensation for artificial windfalls are not applicable here, only natural windfalls. Remember that in this case, we are not seeking to give a better benefit to the plaintiff, just the benefit of the bargain. Therefore, if there is a natural cause of the plaintiff being better off, that's fine so long as the benefit is not artificial or created specifically for additional compensation. However, the non-breaching party has the duty of mitigation to absorb added damages without recompense in an effort to lessen the further accrual of damages. This calls for a reasonable effort and the costs of mitigation are recoverable. The second type of remedy at law is consequential or special damages. This comes from special circumstances surrounding the non-breaching party. In this case, it is plaintiff-specific. There are 3 requirements to qualify for this remedy, including foreseeability at contract formation, subjectivity to reasonable estimation, and unavoidability through reasonable mitigation. The purpose of this is to lessen the ripple effect of extenuating unfairness. The Uniform Commercial Code provides a few formulas that can help determine the exact amount that is appropriate to be recovered by the plaintiff depending on whether the breaching party is the buyer or the seller. Feel free to pause this video to study these formulas. Otherwise, let's move on. unless we want to get into a math lesson. Punitive damages is another form of a remedy at law. The award in this remedy is generally granted only in cases of fraudulent or tortuous conduct. Nominal damages are another remedy at law, and in this case, the plaintiff typically has the burden of proof and cannot prove such damages. Therefore, the damage amounts to a mere dollar. I don't know about you, but I wouldn't be too excited myself if I were awarded nominal damages after spending a sizable amount of money on legal and attorney fees. The last type of remedy of law are liquidated damages. In this scenario, the parties actually predefine the damage amount that will be associated with the event of a breach. There are two requirements for this remedy. First, the actual amount must be difficult to estimate, which is normally the case anyways. Second, the amount set must be reasonable in light of what was known at the contract formation. The next type of remedy includes equitable remedies. There are three kinds of equitable remedies. Rescission and restitution include going back to square one and giving back what was taken. The next type is specific performance, which means forcing the other party to do what they contracted to do in the first place. In order to qualify for this remedy, there must be inadequate money damages, a unique subject matter, and not a personal service contract. The last type of equitable remedy is an implied-in-law contract, which has been discussed earlier. In order to avoid double recovery, parties asking for remedies must choose only one type to the exclusion of others. In other words, you cannot ask for both remedies at law while asking for equitable remedies, lest the balance of justice shifts to unfairly favor the non-breaching party. There is an exception under the Uniform Commercial Code, Article 2, which states that with the sale of goods, a party is allowed to accumulate remedies, but only in a way that would make them more than fully compensated. A waiver of contractual rights refers to the idea that a party knowingly relinquishes their own rights. This is usually done through silence or inaction, waiving a party's statute of limitations. A waiver is very specific and cannot be extended to form another waiver. The pattern of a waiver can be broken, and the original contractual terms can be restored prospectively. Even though a waiver of performance doesn't necessarily waive the right to damages, sometimes it might, depending on the circumstances. So that's all for this discussion. So before you move on to the buying and selling life cycle lecture, make sure to check out the accounting and technical communication lectures as well. Thank you very much.